Welcome everyone to today's webinar on the legal considerations of AI and mental health monitoring. I'm so excited to have an expert here to talk about this major topic in the field of AI in education. For those of you who don't know me, my name is Morgan Sexton. I am Ethics and Privacy Counsel at the Public Interest Privacy Center and Project Director at AASA's Student and Child Privacy Center. Both PIPC and the Student and Child Privacy Center work to provide free resources and as much information as we can on all things student and child privacy. So now I'm going to turn things over to Gretchen and we can dive right into today's topic.
Thank you, Morgan, and thank you to AASA and everyone who's joining us this afternoon. As Morgan mentioned, my name is Gretchen Shipley. I am a partner in a law firm, F3 Law. It's actually short for Fagan, Freeman, and Fullfrost, but I chair a whole legal practice dedicated to education technology. F3 is an education law firm. We work with school districts all over the country. I work with school district administrators on legal issues, and one of the unique perspectives of F3 Law is we try to partner with you in advance of getting a lawsuit. We try to practice preventative law. So policies, guidelines, best practices that we can put in place as a prevention tool for liability. And when AASA asked me to do a series of webinars about artificial intelligence, which is a lot of what my legal practice is, working with school districts, they asked me to identify the three biggest legal issues. And mental health monitoring is probably the biggest area of legal exposure for school districts as we implement AI in the education community. So I think this is really an important topic. I'm really glad you all are here. And it's about what I want to focus on today is making you all aware of where maybe these gaps in legal exposure is and some best practices on how you can shore it up and prevent the legal exposure. So that's my objective. I know a couple housekeeping items. We had a question in the chat, I believe, asking if this slide deck will be made available to the attendees, and I will let Morgan answer that question if she is still here. I would imagine that they can send it out to the attendees. I have no problem with it, and I drafted it, so we will make that available to you all. And then secondly, I know my screen, we are having a little bit of technical difficulties with the screen. So it's the presenter mode's a little funky, but we will just work through it. Please ask questions. I know you all are very busy and it's the end of the school year. So I want to make this helpful and resourceful for you all. And if there's a question that doesn't get answered or you have something specific, my email address is right here on the first and last slide. And I encourage you to reach out to me. I'm more than happy to work with your districts from across the country. So AI and mental health monitoring. This is going to be about 20 minutes, 30 minutes. I'm trying to make it really efficient with use of your time and give you Q&A time. So what I want to focus on is we all know there's a mental health crisis. And so we have students expressing self-harm or threats against the school. And how can we as school district administrators or school districts make sure that we prevention, both in keeping kids safe and, if a district has any sort of knowledge that a student's going to harm themselves or harm people at the school, an act of violence, big area of legal exposure if we don't intervene in a way to try to prevent it. So what I want to talk a little bit about is the role of AI in all of that. Basically, by putting AI tools in the hands of students or even your staff, it's really exposing them to the outside world. It's resharing their data. It's how do we monitor it? This is a quickly emerging area of both the law and of school technology. And so the more, and there's not a lot of oversight right now. So this is not like the fun, sexy part of AI of look at all the cool things it can do, because its applications are amazing. They're revolutionary, both for your business operations, for special education, for educational opportunities. But you all know there's lots of potential for misconduct, but there's a lot of potential for students to engage directly with AI chatbots. And when that happens, we need to make sure we have some sort of safety net when it comes to maybe some mental health threats. So I will provide much more practical information, checklists, tips as we get started. So, it's sort of the boring legal part at the beginning, but we'll try to make it more interesting as it goes. So the first part I want to talk to you all about is just what is a school district's level of responsibility from a legal standpoint to our students. And this is a challenge. I mean, when the laws are written around education, I mean, the biggest national one is called FERPA. Well, FERPA was written in the 1960s. So 60 years later, we now have technology in the hands of students. And to what extent is a district supposed to have oversight of a student's use of technology on campus, off campus? I mean, a lot of the legal requirements are written thinking that everything's done on campus, but now a lot of school districts have one-to-one devices. They have software that can be accessed anytime, any place. And so what is the school district's responsibility for oversight? And so these are some concepts I wanted to go through with you. And they come from different federal and state laws, but generally, you all probably heard of the Latin term in loco parentis. That means when a student is in school, the school is in loco parentis. They stand in the shoes of the parents. You have responsibility over these students when they are on campus, when they are in your care. So how far does that duty of care extend? Because that's really what happens if there is a cyber threat or something happens off campus. The central legal question is, well, is the district still responsible for them after school or on their way home from school or when they're doing their homework online on a district device? How far does that duty of care go? And again, we'll get more into the weeds on that. There's also when your staff members in the classroom have a duty to supervise the students. They have a duty to supervise their use of technology when it's happening right in front of them. So anytime there's sort of a weakness or a lack of duty of care or a lack of duty to supervise or lack of supervision, that's when you can expose yourself to legal liability. Some states, not all, but some states have it expressly written into their constitution. In particular, California, where my practice is located, our state constitution says that students have a right to a safe school environment. Now, what is the school environment? It's not just the classroom anymore. It is now all of their online tools that are assigned by their teachers. So you have to provide a safe environment, not just on campus, but if they're going to be engaging in a learning management system for their homework in the evening, you have to make sure you have the right safety precautions in place. And then finally, the duty to monitor your students' use of the network and the technology tools. That comes from a federal law called the Children's Internet Protection Act, or CIPA. And it says you have a duty to monitor and supervise your students when they are using the district's network, using your devices, which is why you have monitoring software on all of your students, your network and your student devices. But that's where your E-rate, your federal E-rate funds, that's a funding source federally for technology, comes from. And so if you don't have sufficient monitoring software in place and you're not adequately supervising the students, that could put that funding source in jeopardy. And so this slide is really just to demonstrate, and I know you school district administrators are already overwhelmed and overburdened. So to be expected to have to supervise students, not only, or even your staff members, to supervise them in the classroom, but when they're at home using technology in the evening, how realistic is that? How much capability or bandwidth and resources does your district have to even be supervising these students when they're using technology in the evening? And a lot of it is done electronically. It's done through a software program. It can be done through AI to be monitoring them so that they are not threatening to come to the school and have a school shooting the following day, or they're not threatening to harm themselves. So I just wanted to lay this as the foundation that we actually do have an obligation to supervise students while they are in our care. And in our care means also using the district's devices and using software programs that our teachers assign to them. And as we will talk a little bit about, traditional education technology or traditional education software has a lot of privacy protections in place. Open generative AI does not. And so the duty of care is at risk. And again, I'll go into that in more detail, but that's where we need to put up some guardrails around open student use of open generative AI. So we talked about district responsibilities. Where does this come up? The duty of care, I pretty much already mentioned this. It's in the devices. If you give them all Chromebooks or, you know, a one-to-one device or iPads, you have an obligation to have some level of software that blocks out obscenities and blocks out violence and things of that nature. All the educational software platforms that your school district has sanctioned for use in the classroom, those need to be reviewed for data privacy protection. And then now what we're looking at that's kind of opening up this Pandora's box of legal issues is the big infiltration of artificial intelligence into curriculum and instruction. And I'm not here to say that you shouldn't use artificial intelligence for curriculum and instruction. That's not my job. It's just how can we put guardrails in place to make sure that it's being done safely and that you all won't expose yourself to legal liability inadvertently. So we can talk about best practices and policy language and guidelines and things of that nature. And I should mention, this is our second of 3 webinars with AASA on AI. And the first one we did was a much broader overview on best practices for policy and guidelines. And if you weren't able to attend, we provided a lot of resources. So maybe through AASA, you can go back and attend it. I don't know if it's recorded, or feel free to reach out to me and I'd be happy to connect you with the resources that were provided in that introduction webinar. Okay, so I've laid the groundwork for your district responsibilities. And now I want to talk, before we do a deep dive into threat assessment, just some general safety tips for the use of AI. Again, whether it's through your business operations or whether it is directly in the classroom. And those general safety tips, if you can take away one thing from this webinar today, one thing that's really easy to put into your professional development or your back to school code of conduct for your students, is if they are using open generative AI. And what that means, open generative AI means it's not a closed platform that's just data is just reshared within the school site or within the classroom. Open generative AI can be like ChatGPT version 3 that has no privacy settings. It means the information that is put into the prompt and the information that is output is reshared. The knowledge base of ChatGPT is getting smarter and smarter and smarter, and it's reshared with the universe. And anytime you are putting in PII or personally identifiable information, it may be reshared when you have open generative AI. And technically, student records and student educational, you're writing an essay for a class, you're not under FERPA, you're not supposed to be resharing those records with the universe, at least without parent permission. So, anytime, so we need to caution our students and even our staff members not to put personally identifiable information when they're using open generative AI. Another example would be maybe a staff member is using open generative AI to create an IEP for a student, an individualized education plan for special ed student. Well, are they putting in their name and their disability status and their medical information? Again, that's all being reshared. There's no privacy controls. And so it's really important that we tell our staff and our students, do not put in personally identifiable information. The second safety tip is make sure your district has a process in place to review the terms and conditions of educational software for data privacy. So there are a number of state and federal laws that protect privacy for school data. And you need to make sure that the software you're running in your district gets reviewed to make sure it's compliant. It's usually done either by your IT team, your business office, your operations office. There should be some process district-wide that if a staff member wants to use a new educational software in the classroom, that there's a department they can go to and say, has this been reviewed? Has this been vetted? Has this been approved? Has anybody looked at this to make sure that I'm not violating our students' privacy and putting them in harm's way? So again, my second safety tip is make sure you have a process in place for vetting software programs. but that includes free programs and that includes AI. So there's a lot of teachers who think, well, if it's free, I don't really need to ask anybody permission. Well, the problem is some of these AI tools, they're not really regulated or they're not specific to the educational environment. So they don't have those privacy protection measures in place. So even AI resources, please make sure they go through your district vetting process and that you have a process in place. And if you don't, again, I'm happy to work with you on how you can establish that process. Third, parent permission, a safety tip. Open generative AI, as I mentioned, means student records, student information, school projects may be being reshared. And under FERPA, that means you need parent permission. That is different than your typical educational software, a learning management system, maybe it's a reading comprehension program. Those are designed where the data is not reshared with the universe. They're only reshared within your school system and with the software company. They're not reshared with other school districts and other students the way that open generative AI might be. So there's an exception to parent permission for traditional educational software. Parent permission typically is not required, but with open generative AI, it is required. And so we have sample parent permission forms or what the components of parent permission should look like. We talked about that in the first webinar. So again, follow up if you want more details on that. And then the final component, the crux of what I want to talk about today is when you're doing this review of these different AI products, please take a look at whether or not it has any sort of threat assessment evaluation. Because again, I think this is the biggest area of legal exposure for school districts, is if a student were to express a threat of self-harm or a threat against the school and act upon it, was there any means for the software or for the district to intercept and respond to those threats to prevent the harm from happening? So I'll give you a couple of examples. And I know we have some questions in the Q&A. I'm going to just get to those at the end, if that's okay. The examples. So I work with, for example, the state of California wanted to roll out an AI chatbot. They reached out to me to do the legal review. They were going to give it to all high school seniors. And the focus of it was to encourage high school seniors to sign up for the FAFSA, the College Financial Aid Platform. But it was a chatbot that went on all of their cell phones, and they said it was emotionally intelligent. And I like to joke because I have a 17-year-old son, and I say that emotional intelligence is an oxymoron for most 17-year-olds. This was a chatbot that was going to be able to detect their emotions and engage with them. And I mean, they're very sophisticated. And there's even been a study for children that when their chatbot was deleted, they were depressed. They formed a relationship with a chatbot because they have a hard time distinguishing between, engaging with a real person and an AI chatbot. But the idea is, and again, we worked with the state of California to make it legally compliant and put in all the safety guardrails. One of the things we looked at was their threat assessment. We limited the engagement to just be about the FAFSA. And if they asked questions outside of that, it was elevated to a school counselor. But anytime you have a chatbot that can freely engage with a student, the question is the software have a component that's detecting, let's say this chatbot says, "Good morning, Gretchen. How are you doing today? Are you ready for your final?" And I'm like, "No, I'm doing terrible. I want to hurt myself." Or no, I'm going to come to school and, engage in an act of violence against my teacher. Well, the school district put that chatbot in the hands of the students. And so you have that duty of care and duty of responsibility to make sure that you're supervising that use. And the legal standard for liability against a district, when there's harm, when there's actually someone hurts themselves or hurts the school, is did the district know about it or should they have known about it? And that's the case here, is if you're putting the technology in the hands of students, if it's the district assigning it or making it available to them, to what extent do they have a duty of care to that student? Do they have a duty to supervise and monitor its use? And did they know that there was a threat and fail to stop it? Or should they have known? And that's where the kind of the area we're talking about is when you should know, like there should be some threat detection built into these software tools and software programs. So again, chatbots, they may have emotional intelligence component that right away tells you that they're, talking to students in a way that detects if they're angry or upset. I mentioned that the particular chatbot I was referring to, we limited what the student could engage the chatbot in on conversation. We limited it to the FAFSA. You don't need, that can help narrow the focus of. Now, you still may have a student saying, I can't, this form is so complicated, I just want to throw it out the window, or I want to jump off my roof or something, and that might elevate a threat assessment. But, at least it's just limiting it to the FAFSA and not going off in a direction of, an AI chatbot engaging a student about their mental health. And then again, the threat detection and what does that look like? And we'll dive into that a little bit more detail. Another area where AI and threat detection is really important is school districts it's great that they're making counseling more available to students. There is a mental health crisis with youth today, and there are many online counseling tools. They typically use AI to detect threats that students might be expressing, whether self-harm or against other people. So that's another area where we're dealing with vulnerable population. We absolutely need to have some threat detection built into these software programs, because if not, it may be that the school district made this tool available to the student in lieu of counselors that they made available. And if a student threatens to harm themselves and we weren't supervising it, it could create a legal liability. Now, ways to get around that include things like parent permission and a waiver of liability. But in general, if there's really, a school district could be sued anytime somebody hurts themselves or there's damage, or there's violence of something. So we just want to be as protective as possible and make sure and we don't want kids to hurt themselves, obviously. That's the most important thing. So having these threat assessment tools, robust threat assessment tools embedded into these programs is really important. So when you're actually evaluating the software, like what questions should you be asking? And this is so going through this vetting process, it's either your IT team, maybe, or your business office, whomever it is, whoever adopts software for your district. These are sort of walking through, I think I have about 9 different questions you're going to want to ask. And the first one is, does the AI tool even have threat detection capabilities? Sometimes they do, and sometimes they don't. I just want to encourage you that if it doesn't, it's not wrong for a school district to ask the question. Maybe they don't put it into their terms and conditions, and you just need to ask the question. I work with enough software companies in the educational software space that a lot of them just haven't thought of it, and they're willing to add that. They don't want the risk and liability either. And but they're new to the education space. They may typically do private sector type work or not used to working with kids and students. So does it have threat detection? If not, ask for it or don't adopt that particular AI tool. The second is, how sophisticated is it? Can it detect the difference between different levels of threats? So I know I work with a lot of school districts who said that there was, I think it's a movie called The Suicide Squad. And every time it got referenced, the IT team got flagged and they became overwhelmed. Well, AI is really sophisticated. And if it can do the threat detection, can it differentiate between an actual intent to harm oneself or harm another versus, a reference to a movie like that? And so typically the software company on their end can differentiate. We'll go through that initial process of, is this seem to be a valid threat, or is it something that's a miscommunication or, isn't an actual threat? And then a human oversight component. Again, this threat detection is done by AI itself. And so you typically need a human, sometimes it's referred to as a human in the loop. So these are questions that are either right in the terms and conditions of the software that you adopt. These are software programs that you go online and you want to download the app. and it says, do you agree to our terms and conditions? Well, I'm the person who actually reads those terms and conditions. And in theory, you all should be also before you're putting them in the hands of students. So that's, the devil's in the details, and read those terms and conditions and see if they answer these questions. So we definitely recommend a human in the loop to make sure that, if something's going to escalate to a call to law enforcement, or we think it's a true suicide threat, that there is a human double checking that and following through on it. Okay. Your process and procedure. So the first part is what you review in the contract, but evaluate, with the particular software provider and your district's procedures is who receives these threats. So I work with a lot of folks in, IT, and they will say, I worked with one district that said, well, I get the threat detection for 30,000 students. There's only 2 of us, and we don't have the capacity. When my phone rings, I just don't answer it. I let it go to the superintendent. And so that told me, like, they don't, you may have valid threats coming in and you're missing them because people, they don't have the resources. So another factor with your IT team, that same group said, well, we only escalate it after we've had 20 hits. I'm like, well, so the first 19 suicide threats you just ignored. Anyway, it comes down to actually having the capacity to respond. And again, I think in the next slides, we'll talk a little bit more about what that response team can look like. But does it come into IT? Another challenge with IT is they may not have they're not trained in threat assessment. They're not professional counselors. So it's not that it's wrong that it comes into IT. Usually, many districts, it does, but then within your district, you need to have some sort of escalation in process. Sometimes it comes to the site administrator, like principal. Sometimes the threats come to a district administrator because that person said, usually it's the district administrators who will say, okay, somebody has to receive these threats in the middle of the night. They'll volunteer to do it because there's also potential wage and hour issues if you force an employee, a staff member, to be tied to their phone to intercept threats or notices all night long. School counselors, there's usually a team of school counselors that may assist with threat assessment, or you may have a designated threat assessment team. And then one of the other areas that some of the software companies will go directly to law enforcement if they see that it is the highest level of threat, which is important. And so, each software company asks the question, well, if you do get a threat, who do you report it to? Or can the district provide a contact that they report it to? And then internally, your districts, what is your threat assessment protocol, your reporting protocol, who within your team is going to be receiving these, and what do you expect them to do with that information? Additional, I have 5 more questions you can ask here about your software agreements. I just mentioned who's on the threat assessment team. That's kind of goes in conjunction with this is, okay, who are the threats reported to? And then on your end is, okay, and then internally, what does that team look like? Is it multiple people? So when it's only 2 people and that's not enough, the ball might get dropped. You need to make sure it can't just be one person. That person could be on vacation. They could have turned their phone off. Their battery could have died. They could be drunk. Who knows? But you need to have checks and balances within your school system to make sure somebody is receiving the notice and that you have adequate response. And that those folks actually have some knowledge and training in threat assessment, which typically, I'm not like a mental health counselor, but typically it means, does the student have the means to commit violence? Do they have the intent to commit violence? And do they have an actual plan? That's way oversimplifying it, but you want to make sure that the people on the receiving end of these notices know when it can evaluate when it is a true threat and when it's not. The system of checks and balances, again, to make sure you have enough people. You can't have too many people, then no one will respond, but you need to make sure that someone's following up on some of these things. And then setting some expectations with your community, with your parents, about the extent to which a district will undertake this duty of care that I talked about at the beginning. What is reasonable? What do you have the capabilities for? Some districts feel that they have an obligation or they want to take it on because we want to keep kids safe, is they say they will take notifications and threats 24 hours a day. Some say, no, software company, if it's between 10 p.m. and 6 a.m., we want you to report it directly to law enforcement. We don't have people available overnight. Or do you communicate with your parents saying, our district devices and software platforms are monitored during traditional homework hours, which means they go till 10 p.m. How clear can you state to your parents what level of your duty of care you're actually willing to take on? And is it reasonable to expect school districts to have the resources to take phone calls 24 hours a day when there's a threat? Some districts are willing to take that on. It's a little bit of a cost benefit analysis, risk assessment, because some superintendents I work with say, if I have the ability to save a life or prevent a school shooting, I'll take those phone calls in the middle of the night. And I get that. Other school districts say, I have 30,000 students. This isn't realistic. I don't have enough of a team. I need to hire more people. Whatever the case may be, I just think there needs to be clear expectations and communication with your parents about the time period in which the district is doing that monitoring for threat assessment. And then finally, one really interesting bullet point on here, again, interesting at least to me because I'm a lawyer, is do the terms and conditions of the agreement address liability or a hold harmless or release for threat assessment errors or their failure to detect a threat? And I can share with you a story from personal experience. So I mentioned that school districts they purchase threat assessment software itself, monitoring software. And within that monitoring software, so it monitors the district's network, it monitors the devices that go home. And in that terms and conditions, it said, and we take no responsibility if we fail to notify you that there has been a valid threat. I'm like, what are you paying for? I mean, isn't that exactly what they're trying to make it so that if they drop the ball, you're not going to hold them accountable? And that in that particular instance, I encouraged the district, and I mean, I worked with them to negotiate that clause. Like, no, this is what we're paying for, is for you to provide threat assessment. So you should take on some responsibility if you fail to perform these services. So again, a lot of times because of the potential damages, and again, a lawsuit in this area, I mean, if a district knows or should know that a student's going to harm themselves and they fail to intervene, the lawsuits are between about $10 and $20 million. And so, and I don't mean to sound callous, obviously lives are more valuable than money any day, but it's a huge area of liability. So you can understand why a threat assessment software would try to turn around and say that they're not going to be responsible for any mistakes. School district, that's on you. But as a school district, I really encourage you working with your legal counsel or working with us to negotiate these contract provisions and push back and make sure that if you're hiring software specifically to do threat assessment, then they should take on responsibility for any sort of errors. So as your team goes to review these terms and conditions, I just really want to empower you all as district administrators and make you aware that a lot of these software platforms, especially these newer AI platforms, are not specifically tailored for education. So every state has data privacy laws specific to their students. There are federal laws, and I can tell you from personal experience. So again, I'm based out of California, but we have offices throughout the country. But in California, we have one particular statute in our education code that says if you have a software agreement with student records involved, you have to have 11 really specific terms. A lot of software companies don't know that because they don't operate just in this state, they operate nationally. And so you need to make sure that these software companies even know that they need to comply with your state's education laws. They're also not tailored for use by minors. I mean, a lot of AI software is restricted to students under 13 or even restricted to students under 18. So that's something from a safety standpoint you want to take a look at, but they're not taking into consideration that, parent consent may be required. And I already mentioned that you may have state specific requirements. and that you really should feel empowered to question these things from the software company or negotiate these terms and conditions. Because I often find, I work with about 500 different school districts. I'm general counsel for an organization called SITE, California IT for Education, and all we do is negotiate with software vendors these contracts. And more often than not, the software vendors are not familiar with laws that apply to students and student records, and we are educating them. And in these days with our budgets, the software companies should shoulder that burden of making safe products to be in the hands of students, but a lot of them just don't know. And if they're not making a safe product, it's important then that these school districts are purchasing safe products for students. And in doing that, it's doing this review, looking at these particular terms, asking these questions, because again, we just really don't want there to be any sort of threat. And I know we have some questions in the chat, so I'm going to turn to that next. I just want to, as I wrap up on the substantive content here, just a little bit about what I do more specifically and what my team of attorneys does. We have what we typically do we do all areas of ed tech, we do all areas of education law. But what I will do is I will work on policy with districts and guidelines for best practices of AI or social media, any area of ed tech. We do the contract review process and procedure. We do all the student data privacy compliance, and we provide trainings, like even virtual trainings for your staff, for your students, or for your admin team. So, and I have a link here. We also, totally an aside, we just did the US Supreme Court case about school board member use of social media. And with an election coming up, we're fielding a lot of questions on that too. That's another area of virtual training related to technology that we can offer school districts. So I am going to turn to the chat area here, and I'll leave my email address up on here for anybody who wants to contact me. And Morgan, I can just run through these questions if you don't mind. Let's see. Oh, Morgan's been putting all kinds of good comments in here. Morgan, I'll let you go through your comments in the chat if you'd like to, but I'm going to go to the Q&A first. So does the responsibility change when students are in a virtual school? I think a virtual school is still responsible for making sure that the educational software that you are putting in front of students protects their privacy, and you still have a duty of care to those students that they cannot misuse the online training tools. So I would say that, yeah, you still have that same level of, obviously you can't supervise the same way you could physically in a classroom, but you need to have monitoring software, and you need to have, there's still a duty of care to, if they're putting violence or obscenities, you probably have a monitoring software that will block that anyway, or maybe block. I don't know if your virtual school provides the device, but those devices should have blocks for what kind of websites. But ultimately, if through your virtual school, you make educational software programs available, those programs need to meet these same standards in their terms and conditions as far as, threat assessment, monitoring, or any of the data privacy standards. The next question, this is a great question. Is there such thing as closed generative AI? Again, and I'm a lawyer, not a computer expert, technology expert. So somebody else might be able to answer this question better than I have. But my understanding is there's closed AI, which means it stays within the school environment. And there is open AI, which means it is reshared. The generative piece comes from its ability to build a knowledge base, to generate additional information. If it is closed and limited to your classroom, in theory, I suppose it could still be getting smarter, but it's the resharing is limited. Generative AI typically comes up in the open environment, like the open ChatGPT version 3 is open and generative. Closed, you're not going to get the same level of sophistication that you have with open AI, because it's going to be a much more limited base. But yeah, so that's the difference between open and closed, and a little bit about how generative can come in there. Like if it's only open, if it's only available to one classroom of students, it's only going to generate content from the students in that classroom. I hope that makes sense. Oh, and Morgan, I know you said you'd like to answer that question. Do you want to jump in?
Oh, no, I'm sorry. I was just putting it that it was being answered live for the
Oh,
recording.
got it. Okay, great. Thank you. The next question is, you mentioned that school districts have a duty to monitor students. Can you talk more about where this duty comes from and what roles AI and people should play in the monitoring process? So one area that the duty of monitor comes into, the most central area, is there's a federal law called CIPA, Children's Internet Protection Act, and it says you have a duty to supervise and monitor students' use of your network and I believe district devices. And so like, how broad does that go? Children's Internet Protection Act, you have to comply with it. You have to comply with that monitoring duty from in order to be eligible for federal E-rate funds, which are technology funds that districts receive, sometimes in the millions. So school districts want to make sure they don't violate that. There was also, I mentioned at the beginning, in loco parentis means anytime you are educating a student, you stand in the shoes of your parent. There's a sort of common law duty of care we owe to children when they're in our care. And so so it's this general duty to supervise, that's, and to discipline them and prevent misconduct. So if you, not to mention like mandatory reporting, as a mandatory reporting for child abuse and neglect, that's a state specific law, but, almost all teachers, that's another area where kind of supervision and monitoring can come in. So what happens is if there is an oversight by a district and a student harms themselves or, commits violence against the school, a parent if they were going to bring a lawsuit against the district, they would hit on every state law, federal law, common law there's several areas where these duties come from. That's why I think I listed 5 slides at the beginning. And again, in California, they have kind of even a constitutional requirement that we have a safe school environment, but the duty to monitor specifically most commonly comes up under that Children's Internet Protection Act. But it really there's several laws that talk about our duty to care to students generally. And then with AI, the reason why that comes into play is because the reason why it's particularly risky is because AI chatbots, they're just engaging back and forth with a computer or their data is being reshared. And so it's just because it's new technology that I want to heighten the awareness that we're still reviewing these terms and conditions, just like you would if you were adopting a student information system. We have a lot of staff members and students who are excited to use it. And I'm not saying you shouldn't use it. It just needs to be vetted because it's new. It's often free. It's so tempting to use because its capabilities are remarkable that we want to make sure you do a safety review for these tools also. And what role should people play? That's again where, district administration comes in anytime you're, whether it's your curriculum and instruction team that adopts software for your school district, or it's your business office or your technology office. I think as district administrators, and then, doing professional development for your staff to make sure that they're not inadvertently putting risky tools in front of students. Thanks for the first session video. Is there a link to the resources shared too? Morgan, I will let you all email that out to the group, or I'll make those available. And then finally, I was wondering if you can talk more about considerations for monitoring activity on school issued devices, especially when the monitoring takes place outside of school hours or off school property. And this is something that I also talked about a little bit and I touched on is, if it is an assignment and they're doing their homework and it is through a school issued device, and if it is through school issued software, the district still has a responsibility to monitor and supervise that use, which is why the threat assessment software is so important to have in place. And have some sort of threat detection, not only threats, but also violence and obscenities and all data privacy tools. You don't want them interacting with strangers online, So again, I think when we are talking about outside of school hours, Now, if they're on their own time and they're using their own computer and they're doing homework, but they're researching it on Google or Chat GPT from their own, there's only so much we can expect from schools. Your duty of care only goes so far. But with technology, we're in a real gray area because again, these laws are from the 1960s, and we're trying to say, how far does school district's duty of care go? How far are you going to be held responsible if a student does something wrong or dangerous or engages in misconduct on your watch? How far is your watch supposed to go? What's reasonable? Well, if you're giving them devices and you're giving them software and you're assigning them school work, I think and you have the ability, there's software out there that can do threat detection monitoring, or it can, you have this obligation to monitor their use of these devices, then I think it's reasonable that school districts will be held accountable for, it's all about a reasonableness standard, but it'll be reasonable to expect a school district within at least regular homework hours be doing that monitoring. But I must confess, it's a gray area of the law about how far does the duty of care go. So I'm taking sort of a conservative approach, saying, do what you can, do what's reasonable with the amount of staff you have and resources that you have. Next, can we say more about what equity issues we should be talking about related to threat detection? That is a great question. So equity comes up in a variety of ways when we talk about AI. I mentioned earlier a chatbot that engages with students. And one area of equity, not specific to threat detection, but in general, is the fact that if you're going to make AI tools available to students, it can't be something that just goes to their phone. Not every student has a phone. You need to make sure it's available to students. It might be through your website. It might be through their district issued device. But we also need to think about students with disabilities and that the tools we're using are ADA compliant. And then as far as threat detection, one thing that's interesting is, unfortunately, a lot of AI, just like the internet, has some inherent bias. And so are we missing a gap of students because the AI, the threat detection hasn't gotten smart enough to detect nuances in different, the way different populations of students use language or the way they might express themselves. So I think that is part of doing your evaluation when you're asking questions of your software provider or you're reviewing the terms and conditions is, I think somewhere in the presentation I talked about like accuracy, like, is there a human in the loop? Do they, how smart is how robust is the software company's threat detection process? It may be pretty basic and they put the burden back on the district to sort through what's a real threat and what's not. It can be very robust in some cases, but that's part of the evaluation when you're looking at the different tools to determine whether or not you feel like you have adequate protection or not. And I know we have run over the 45 minutes, so I think we need to cut off the questions there. But again, I have my email address posted here, and I really would welcome any follow-up questions or encourage you all to contact me if we can be of any support as you, but I'm just thrilled that you all attended because I think this is a really important area of legal liability and it's happening. It's booming. AI is happening in schools, whether we know it or not. And I just want to make sure that you all we're making sure that we're keeping kids safe to the best of our ability. So thank you again to AASA and to the attendees. And I look forward to hopefully meeting you all again in our third session.
Yes, thank you so much, Gretchen.
And it's going to be focused on special education specifically on June 18th.